Unpublished Opinions, an Institute for Justice Roundtable podcast. The podcast where Institute for Justice attorneys give their unvarnished and unpublished opinions about the law. Well, this is the first episode of the new year. I'm not going to say Happy New Year because apparently that's verboten after about January 7th or so I've been told. But I will welcome you, listeners, to the new year. I am your host, Anthony Sanders, this month with our first episode of 2025. And joining me as part of our regular roundtable this time is Diana Simpson and Patrick Giacomo of the Institute for Justice. We're going to talk about some legal stuff. I give you a little bit of inside baseball on what's going on the show. As we are recording this, we are pretty sure that in just a few minutes, the Institute for Justice, we don't release opinions. The Supreme Court, the United States Supreme Court, is going to issue some kind of opinion, and we're pretty sure it's to do with the TikTok case. So when you're listening to this, you're going to know what happened. You're in the future, even if it's just a couple days from now. We're recording this on January 17th, 2025. So we may have a little live casting of the opinion, not because you need to know what happens, because you already know what happens, but to give our deep and considered thoughts about it time. So we have a few things we'd like to talk about today. One, though, that people seemed into is kind of broadly speaking, courts and technology. I have some thoughts about courts and their web pages and how they run them. But I know Patrick has some pointed views on this. Patrick.
Yeah, I mean, the pointed view from my perspective, and by the way, I should say before we get started, Happy New Year, everybody. All the haters, I also hope you have a Happy New Year as well.
Man, when do you stop saying Happy New Year?
I think probably once you've done the first thing of the year, unless you're like, I'd say anytime in January, you're safe to say Happy New Year.
So Larry David has issues with that.
Yeah, well, if Larry wants to come on the pod, we can talk about that. And I would be happy to join that conversation.
Is your Christmas tree still up, by the way? Like, I think might revolve around that.
No. We have discarded the Christmas tree entirely. There's no evidence of Christmas in our house except the giant pile of things behind me in the basement that still need to be put away and warehoused in the garage.
I put away the last nutcracker yesterday. He was just kind of hanging out in the corner and like, I got you.
So sad. But there's always next year. And that's what we told my daughter. And that seemed to tide her over. So anyway, back to the point about courts and technology. Yeah, I mean, most of my pointed complaints have to do with, filing systems or the lack thereof and all sorts of strange requirements that don't seem to make a lot of sense. And frankly, the fact that Pacer still exists and gives you the one free look and doesn't just allow all of the public documents to actually be made public. And my big complaint with Pacer in general is just the small hurdle of having to sign in, even when you're a lawyer and you have a Pacer account, of having to sign in and accept the charge, find it. It's a very cumbersome system, and then accept the charges and then see the thing. Just seems like completely unnecessary. Whatever the costs that would be lost by making Pacer free, they could make up for some other way. I mean, we all have to pay to be admitted to different district and circuit courts around the country for no apparent reason. So those fees could go up, or filing fees could go up, or who knows? There's any number of ways they could do it. But it's frustrating because it's a hurdle to normal people. And so they're not going to bother to do any of those things. And therefore, they're stuck relying on media coverage of cases, which, of course, regularly leave out the actual filings and, maybe misconstrue them sometimes. And so I think there's all these downstream effects from the fact that courts in general, and Pacer is probably one of the better systems you see. If you start looking in state courts, it's usually just a total hodgepodge. I practiced in Michigan for 8 years before I came to IJ. And, the appellate systems, there was a computer system. But by the time I left, and I don't know the current status, it was just kind of on a county by county basis. And so some counties would have the same filing system as the Court of Appeals, and others would have no electronic filing at all. And you would actually have to, on a Friday, pay 5 cents a page to fax filings in if you couldn't physically get to some
fax
far-flung
filing
county.
still exists.
Oh yeah, or it's wild because there's still plenty of places, as we do work all across the country in lots of small places, and you want to look up, arrest records or property records or whatever, and you'll call down to the local clerk's office and they'll be like, yeah, we can get that for you. It's X cents a page and we can either fax it or we can mail it. We can't even, you kind of have to sweet talk them. And if you're lucky, you can get them to email something to you, but that even feels like a stretch in these places. And so I think so much of this could save everybody, including the courts and the court staff and county clerks, a lot of time if we could sort of agree that the technology of at least like 2008 should be imported into the court systems. And then we can kind of work on the finer details from there.
I mean, Pacer, I think, makes sense and it works for the singular purpose of alerting the parties to a case that a decision has come in or a filing has been done or whatever. I think that system works. It's not ideal, but it's okay. And then they figured out how to do that in, I don't know, 1997 when GeoCities was still a thing. And then they just haven't updated it at all since then. And they continue to charge an enormous amount of money, realistically, when thinking about like the actual costs involved on the government side. And I suspect Pacer's making money for the government, which I don't think it's supposed to do.
Yeah, although I don't know if it makes a lot. I mean, the weird thing is they cap it. So it's only like the most you can pay for a document is like $3.
Yeah, but that's
so
per document. So if you have exhibits, that's $3 per exhibit.
Yeah,
if you want to read an MSJ,
I'm not saying it's not real money. I'm saying it's not optimized to make money.
No. If they wanted to make a lot of money, they could run it better. If they wanted to provide public access to public documents, they could make it better. Like, it's basically they just decided how it worked in the 90s, and then that was it. and they just stopped caring on any. There's never been an effort to improve it, and I think they should improve it. They could outsource it. They could say, you know what, we're done with it. Somebody else come in. We'll contract with some private company to make it better, and we'll use your bar admissions or whatever to pay for the access to it, and then that's that. I'd be happy to pay for that.
So one thing that I was skeptical when it started happening, but is a little better is the I forget what they call it, the next gen of Pacer, where it's universal. So you have the same login and password for different courts. I don't know if all courts have gone to that, but a lot have. And that is better, especially when you practice in various jurisdictions. So you look at, or you're trying to get documents. So you look at one, like to get ready for short circuit, often I will look at, what's going on with this case and this one. Kind of re-log in between them, but it's super easy. Whereas it used to just be like totally different login for each.
Yeah, no, there have been those sorts of improvements, and then my other gripes with some of this technology stuff are kind of minor, but you'll get these situations that are common. These are recurring things where you have to file something in Pacer in a circuit court or a district court, and then the next thing you do requires you to file it again. And so they're going to have the stamps in the same exact place, stamping over each other with all of like the filing details of when it was filed and what number it was, and it becomes completely unreadable. It's like you think that the systems, knowing that there are certain things that fall every single time into that category, would like be able to overwrite that portion instead of just having it turn out to be complete gobbledygook. And then you have some circuit courts that require you to provide them paper copies that don't have the stamps in them. And you have some courts that require you to have the ECF stamps. And so then referring to page numbers can get kind of confusing. And, notwithstanding how many times I've done it, every single time I'm working on a reply brief in one circuit or another, I have to sit there for 5 minutes and decide whether it makes more sense to refer to the ECF number or the actual page number. And
isn't there usually a local rule saying use the ECF number or use whatever?
Sometimes.
Yeah, and it's not the same, and so sometimes you just have to deduce it. It's not ideal.
It's just like the judges' little picadillos about what they prefer. Which, okay, fine, your world, I'm living in it, but it makes it difficult for people who practice in more than one jurisdiction, which we do. Another one of the frustrating things that I see is if you have something that isn't a piece of paper with words on it that you want filed, it is enormously challenging. And so we have a video in one of our cases. In fact, videos are super common, right? And you want to get the video in front of the judge because there's perhaps no clearer piece of evidence as to what happened than letting the judge see for themselves based on this particular video, body cam or whatever.
And we know now circuit court judges love seeing videos. But
they sure don't make it easy to get it in front of them. You know, to file video, you often have to file a separate motion saying, okay, I've got things that are not, whether it's a video or pictures or whatever, I've got things that aren't, pieces of paper with words on them. Please give me leave to file them. And so then you have to file this motion. You have to see if it's contested by the other side. And then you send it into the court on a thumb drive or a CD, which I don't even think my laptop has the ability to do CDs anymore. And so it's just, it's on the internet. Why can't I just send it to you that way? Like there's a YouTube link. You can go check it out. And then they often end up citing the YouTube link, but like actually getting it into the record is so difficult in a way that it just doesn't need to be. And it's, I think it's just, well, we figured out a way for it a long time ago. It's going to be hard to change. So we're just not going to change it. You guys deal with it.
I agree. And I think, to your point, it's actually kind of remarkable to me how often I will see cases we've taken over or cases we're investigating or whatever, a case that we didn't litigate before, where the only evidence of there being a video will be literally a copy machine image of a CD that says it was sent to the court. And so my advice for everyone listening, if you're an attorney, is if you have a video or videos that you want someone to actually watch, regardless of all the hoop jumping that Diana said, which of course you're still going to have to go through, please, for the love of God, put it on YouTube or put it on some other video hosting service so anyone coming after that will be able to see it. I think the same is true if you have pictures that are particularly consequential. Those are things that you probably should consider putting in the body of your brief or some other document form because
they don't add to the word count, it seems.
No, it's sometimes it's great. I'll refer occasionally to like documents between like the federal government and local authorities or whatever that will have words in them. And I will, clip the relevant section highlighting the words that I want. And it's like, yeah, here's more words in my brief that don't actually count against my word count because this is just an image to show to the court like, hey, this is a real document. So maybe if you want to then go interrogate the rest of it, take a second step. But if you need them to see the video or the pictures in the first step, making them, this is kind of circling back to my original complaint about PACER is, even though they're courts and clerks and they're supposed to be interrogating this stuff carefully, the easier you make it for them to see, the more likely that they're going to give it real consideration. Because, if they wake up early on the morning of the day of the hearing and they're flipping through your brief, chances are they're not going to have time to then go ask the clerk where the thumb drive went and put it in their computer and pull up the file and look at the timestamp.
So there's no video on PACER, right? That's not a thing? Or can there be?
I don't think so.
I don't think I've seen any. I mean, you could like what I intend to do in my brief is file the motion to send the video in, do all of that like ridiculous stuff, and then drop a footnote when I cite to it that says available at youtube.com/.
One good thing about paper filing, although this was only true for like maybe a decade or so, it was we had a paper filing once and there was this huge file. It was a PDF file. And we just put it on the thumb drive and like stuck it kind of in an appendix to the brief in a little plastic baggie and said like, here's thumb drive. And I couldn't find a rule that regulated how to do that. I put in a footnote, hey, you got a thumb drive in the thingy. Opposing counsel never objected. I have no idea if the judge even ever looked at it, but you could do that. And electronically, it gets a lot more complicated. They all have different systems, even within a state. Sometimes, some counties are way ahead of other counties. That is super frustrating, but in some ways it just reflects like the multiplicity of local rules and practice that you get that's inherent in the system. I don't mean necessarily inherent, but it's how the American legal system works. So it's kind of not surprising that when different courts come up with their own things, you would think it's universal, but it's actually as varied as local rules, which are just so. I'm always surprised how varied local rules, even within a state, but from state to state, are. It's like you learn, like the justification for the bar exam is that, well, every state has its own law, so you got to learn, different law, which we know isn't actually that true. Like, sure, they have statutes, but you can look them up in a hurry. And the way you actually think about legal principles is pretty similar from state to state. Like, oh, this state has this kind of tort law and this has another, but basically 90% of it is the same, except when it comes to like the actual practice where the local rules can be wildly different. So it's like you have a bar exam for, even though this isn't what they test on the bar exam, the part of the bar exam that actually makes sense would be all the stupid hurdles you have to actually practice. And that translates into technology.
Oh, yeah, sure. And then, of course, for those of you listening who don't practice law, you have all these local rules. You have a sort of standardized set of rules, like the federal rules of civil procedure. And then you'll have the local rules of whatever district court you're in. And then depending on what judge you have, you might even have like a dozens of pages long judges
standing
preferences or orders or multiple standing orders about this thing or that thing. And you have to cross-reference like.
And are they on the judge's website? You always have to check.
Right.
Well, they'll conflict with each other or they'll conflict with common sense. Like the Eastern District of New York, you don't actually file a motion the day the motion is due. You file a letter saying, I'm going to file a motion and it's going to say these things. And then the other side files a letter in response to your letter saying, I'm going to oppose your forthcoming motion and I'm going to say these. And and then you just you exchange the briefs with each other. And I suspect, I don't know, but I suspect it's to not start the 6-month clock until the issue is fully briefed, because then everything is just filed on the last day.
That's so cynical, Diane.
Maybe there's another reason I haven't considered, but like that seems to conflict with the kind of plain language in the rules about when a motion must be filed, like a 12B motion or whatever. But never mind. Just read everything. Read the federal rules, read the local rules, read the judge's preferences, read anything you can find. And it takes a lot of time to do that.
One other thing about court websites I wanted to bring up is opinions on websites, which like lawyers who, follow the latest going on in the law, we use that a lot. And I think the general public probably who's just interested uses that a lot, and especially reporters who include a link to the opinion, thank you, as some maybe don't. Then you will see that opinion, and it's not an opinion on Westlaw or Lexis. It's like the PDF that the court happens to upload. Some courts do a good job of that, and some courts seems like kind of an afterthought. Like the courts that still have the opinion in Courier. Who wants to read the opinion in Courier? First Circuit, or even some state court. I think New Jersey still does that. No. Maybe I'm wrong about that. But
pox on their house.
What are they thinking with these unreadable PDFs?
I don't know.
They're for the public.
All power to the Fifth Circuit, which has switched over to Equity. Equity is beautiful. I love it. I use it for my own briefs. I think it's fantastic. I don't understand. Like, Times New Roman is not pretty. I don't like it, but it's at least better than Courier. You've got Garamond, which I will forever and always use when I have a page limit rather than a word limit. Sorry, courts, if you want bigger letters, you're going to have to give me word limits, not page limits. But I think they should just do what a lot of courts, I think the Seventh Circuit does, which basically says, give us something that's readable. Thank you.
Yeah, I don't want to get off on the tangent into the text and into the fonts thing. I keep coming back to Century School Book after all these years. I try other things.
It is lovely.
But the thing that frustrates me too is there are a lot of times when, you go to a court website and you just want to see like an opinion that court put out in the last month or two, and you have to hunt around for it. Like, is that not probably the most important thing that the court would want to be publishing to the world? Is like, hey, our job is to decide these cases. And, if we're a state Supreme Court, maybe we decide 80 to 100 a year. Don't you think that would be the very first thing that you'd want to put up on the website? And oftentimes you have to go and you have to hunt through, and then there'll be some search function and you'll find the case and you click the case and it'll pull up like the entire appellate docket. It's like, can we just start with the opinion and then we can sort of sift back through that? And it is not very user-friendly in many instances.
So speaking of opinions on websites.
Oh, it's 10 o'clock.
The TikTok opinion is out.
Oh, boy.
So dear listeners, we're probably going to cut out some
and that's it.
Silences here. But we're going to take a look. 27 pages per curiam.
Whoa.
DC Circuit is affirmed. So that means TikTok loses.
And of course, we begin with the our analysis must be understood to be narrowly focused in light of these circumstances, which,
very Bush v. Gore energy.
It is a phrase that I feel like you put in there if you're like, I'm not so sure about what we're doing here.
So we got Sotomayor concurs, Gorsuch concurs, Gorsuch complains. We fortnight. The word fortnight makes an appearance. We've had a fortnight to resolve.
Oh, I thought you meant the game.
No, sorry, Patrick. I'm not thinking Justice Gorsuch is a huge Fortnite player. I mean, maybe.
I doubt it. Interesting. I'm surprised they didn't do kind of like a placeholder decision and then, a couple months from now issue like this big old love letter to the
Those
First
are the
Amendment
only separate opinions.
This is wild. Although both our current president and our next president have said that they are not going to enforce it. So what is the practical effect of this opinion and of that law? I don't know.
Oh, listen to this paragraph. At the same time, a law targeting a foreign adversary's control over a communications platform is in many ways different in kind from the regulations of non-expressive activity that we have subjected to First Amendment scrutiny. Those differences, the act's focus on a foreign government, the congressionally determined adversary relationship between that foreign government and the United States, and the causal steps between the regulations and the alleged burden on protected speech, may impact whether First Amendment scrutiny applies.
What?
That's just an invitation now for the talisman of national security to be placed on every single speech protecting or speech annihilating act of any
it gives courts a
legislature.
lot of options. May.
Well, that's ridiculous. Okay. The First Amendment applies. You just figure out whether it passes scrutiny. Oh.
Facially content neutral.
That's what they say. They say the ban is.
They say the challenge provisions are facially content neutral. Well, they assume without deciding that the challenge provisions fall within this category, whatever that is, and are subject to First Amendment scrutiny.
Okay, but what scrutiny? It says the Act's TikTok-specific distinctions do not trigger strict scrutiny. Okay, but while laws favoring some speakers over others demand strict scrutiny when the legislature's speaker preferences reflect a content preference, such scrutiny is unwarranted when the differential treatment is justified by some special characteristic of the particular speaker being regulated.
No more than intermediate scrutiny is in order.
So they're still hedging on that.
Yeah. And then as applied, the act satisfies intermediate scrutiny because the challenge provisions further an important government interest unrelated to the suppression of free expression and do not burden substantially more speech than necessary to further that interest.
Right. No more than intermediate scrutiny is in order. Well, that makes it easier for him.
So Justice Sotomayor concurring in the judgment. I join all but Part 2A of the court's per curiam opinion. I see no reason to assume without deciding that the act implicates the First Amendment because our precedent leaves no doubt that it does. And then she ends by saying, as to the remainder of the per curiam opinion, I agree that the act survives petitioner's First Amendment challenge.
So no one says strict scrutiny applies?
Doesn't look like it.
Well, yeah, so Gorsuch says, I harbor serious reservations about whether the law before us is, quote, content neutral and thus escapes strict scrutiny. He says, all I can say is that at this time and under these constraints, the problem appears real and the response to it is not unconstitutional. Basically saying, I didn't have enough time to figure this out, guys.
I don't understand why they didn't just issue an order and then come back and fill it in with a decision later.
Well, I guess the rest of them are pretty sure.
I don't see how you could be so sure so quickly.
Well, yeah. I mean, it does seem that opinions issued at the end of April or argued at the end of April and then have to come out by the end of June are some of the worst reasoned opinions. So this is going to be even more than that. It's kind of surprising is, compare this to, say, I mean, the most famous one is the Pentagon Papers case, where there was a very short per curiam, and then there were all these opinions, but none of them were majority opinions because I think because they weren't majority opinions, the justices felt they could kind of riff more, even though it was in short order. And it was security. It was kind of less of a novel thing because it was about prior restraint, whereas this TikTok thing, what's going on with China is, pretty new. And yet here we have the per curiam, 7 justices all lined up like they're on the same page. So, although it is per curiam, right? So we only know that 5 justices signed on. I mean, I'm betting some of those justices signed on, but who knows?
I mean, maybe.
Well, there we go. So TikTok lives at the grace of the presidency, like many things in life. Please check out Short Circuit's TikTok account and in the Institute for Justice TikTok account if you haven't.
By Sunday.
Well, we'll see. We'll see what happens on Sunday. This by the time you're listening to this, which is probably after Sunday, then I don't know. Maybe the TikTok app will not be there anymore. But we're going to talk about something less exciting than TikTok, and that's pornography. Because I think Diana has some thoughts about that.
I do, and you know what? There's probably a lot of pornography on TikTok. I don't know. I'm too old to have a TikTok.
I think they try to keep that off, like the stuff that was worried about at oral argument the other day at the Supreme Court about the Texas law. I think that kind of stuff isn't on TikTok. I mean, maybe if you search hard enough.
I don't know. I'm not searching. Like I said, I don't have a TikTok. I'm not interested in the substance of this stuff. But
let's be careful with the framing, Anthony.
The Supreme Court heard oral argument in Free Speech Coalition v. Paxton, which I found to be an interesting case. I followed it. We at IJ wrote an amicus brief on it that was actually name dropped at oral argument. So that's always exciting. But very briefly, the law basically just imposes a requirement. It's a Texas law that imposes requirements on commercial website that consist of 1/3 or more sexual material that would be harmful to minors. And this includes all kinds of sexually suggestive content, including rated R movies. And so it's a definition that's like nearly identical to the federal definition. Importantly, it exempts search engines, and it also, by its nature, exempts social media platforms that have less than 1/3 sexual material, even if they have way more sexual material than like an actual porn website might, right? So like you can go get the same material on Instagram because there's just so much stuff on Instagram that the sex stuff isn't a full third. And so the covered websites have to verify the age of every user. They're not supposed to retain the information. And then they're supposed to post warnings condemning the content as harmful to health. And the warnings were not at issue at the Supreme Court this time. But there's no prohibition on transferring the data or disclosing it to other people. So this could be a big privacy issue. So the district court entered a preliminary injunction saying that the law was subject to strict scrutiny and it was unlikely to pass strict scrutiny. The Fifth Circuit then vacated it, saying, no, this is actually a rational basis test, and it definitely survives rational basis. And so the case ends up really rising or falling on what the level of scrutiny is. Is it rational basis? Is it strict scrutiny? And there's a whole host of Supreme Court cases on this. There's a 1968 case called Ginsburg, that basically applies the rational basis test to a New York law that prohibits the sale to minors of this kind of material. And so the store owners would have to require basically your ID, but it's in person as opposed to online. But it appeared in what was called girly magazines. And so you get the benefit, if you listen to oral argument, you get the benefit of hearing Justice Alito talk about girly magazines, which is awkward. And I appreciate that.
I would love it if any of the advocates were just up there and they were going to play dumb. They're like, what's a girly magazine? It's also been very curious, like when the shorthand porn took over from porno. I mean, obviously the benefit of having one less syllable is there, but porno is clearly outdated. But at some point, like, it was accepted as the way of describing. So,
well, like the late 90s, maybe?
That sounds right. Right. But I wonder why.
I don't know.
Is it general law of language that you drop syllables, perhaps?
Is that why the Brits drop all their syllables?
I mean, I have this fight internally at IJ because everyone there calls shorthand for depositions is depo, and I came up calling them deps. So I don't know. I guess IJ is doing the porno thing, and I'm doing the porn thing. Clip this audio, folks.
So anyway, the oral argument is interesting. Obviously, Justice Alito is very much in support of this law, which, and when I say obviously, it's because, I think there have been a lot of kind of 8-1 Supreme Court First Amendment decisions over the years involving speech.
He is not Mr. First Amendment.
No. There was the Animal Crush videos. There were the protests at funerals. That case. There have been a lot of them where they've been 8-1 and he's been the one. And so he, I think, ran with the this law is totally constitutional, right? And, I think he took a lot of time on that. But the reason that I bring this up, the reason that I think this is particularly interesting is because this whole case is about strict scrutiny or rational basis. Because if it's strict scrutiny, that's going to be fatal in fact, probably. Like, is the government just absolutely going to lose if strict scrutiny applies? On the other hand, if it's rational basis, the government absolutely wins. Like, is that the way the world should work? Like, at the Institute for Justice, we do litigate rational basis cases. We've won them. They are very difficult to win. But I don't think it should ever be the case that it's just the standard of review dictates the outcome. And that's absolutely what's happening in this case. And that's what you're seeing is that, whether the First Amendment applies and how the First Amendment applies is the ultimate answer as to who wins, regardless of evidence. And I don't think that's the role of the judiciary. I don't think that's the role of this system. I say this, I've skipped a big part of it, and that's that there is no First Amendment protection for material that is obscene for minors. So kids do not have a right to this kind of image, right? But that same image can be totally constitutionally protected for an adult. And so where does the First Amendment apply? And does the First Amendment apply? And that's like a big issue in the case. And so it's frustrating to me because I think the First Amendment should necessarily apply because this is speech. Whether it's speech you agree with, whether it's speech you like, it is still speech. It's expressive conduct. It's, images that, whatever, images of all kinds. And that's traditionally under the First Amendment umbrella. And so shouldn't it be the case that you then analyze whether that material is constitutionally protected, not based on which standard should apply, but based on the evidence at issue as to whether this law works, whether this law is narrowly tailored, whether this law includes too much protected material, that like those kinds of questions that, I don't think are actually in the record yet because it's still just on a preliminary injunction.
I was just going to say, no, I think you're totally right. I mean, that is the problem. There will be, whether you can win a rational basis case or lose a strict scrutiny case in like the abstract, all set aside, there will be many cases like this where, like you said, Diana, the standard will control the outcome of the case. There's going to be no factual development. It seems to me that if rational basis applies here, that will allow the people challenging the law to win and vice versa. So it is very frustrating that we're kind of, and there are lots of other examples like this in the way the law works, and all of them are equally frustrating, where we sort of pretending like what we're doing is this abstract procedural dance, but actually what we're doing is deciding the case without actually deciding the fundamental merits of the dispute. Yeah. And that seems like, a way that courts have evolved over time to sort of shield themselves from the scrutiny of actually saying this or that.
And it's not even just a strict scrutiny versus intermediate scrutiny versus rational basis thing too. There's all kinds of like gatekeeping in this area where the gate becomes the thing instead of the analysis after the gate. So another one is, right, in equal protection claims, some states do this more than the federal courts do, and sometimes the federal courts don't care, and sometimes they do. But whether something is similarly situated, and then so you're like, okay, is it similarly situated? Yes, they are. Then you get to, okay, well, is there a rational basis or is there whatever? And courts spend a super amount of time saying, oh, it's not similarly situated. So then we don't have to get to those other questions. And I don't have to give the examples, but this has been frustrating in many of our cases and many other cases you'll read out there. And you can tell what's really going on is the court says, wow, that's a sticky wicket. I don't want to get to the actual, scrutiny part. So we're just going to throw it out on other grounds. I mean, there's all kinds of these. Qualified immunity. I mean, it's kind of a huge family in the law, right? Yeah. Whereas what these tiers of scrutiny are set up for really is to do the actual, you may hate them, but to do the actual analysis. Like strict scrutiny was not set up to make everyone lose all the time, although that's often what happens. But there's actual analysis that's supposed to go on there, but because they don't want to do the analysis, they don't get there.
So should we abandon the tiers of scrutiny?
Well, I have written on this separately, and there may be people who disagree with me on that, who are kind of an Institute for Justice bent. But I have written about how so the tiers of rights that we have, so fundamental rights versus non-fundamental rights, that is dumb. And I think a lot of people agree with that, because then you have rights that don't get any protection on a rational basis, and then the rights that get a lot of protection. But like, what's the answer to that? And so a hardcore libertarian might say the answer to that is strict scrutiny for everything. And although some of us would like to live in that world, right, is that sustainable if we had strict scrutiny for everything? Probably not. If you had that at the state level, you would have a lot of constitutional amendments. If you had it at the federal level, like, I don't know what would happen, but a lot of laws that a lot of people like are going to be, not just like stupid laws, are going to be out the window. So what is the answer? And what I've floated in some of what I've written is kind of like, maybe there's a bargain out there, like kind of good government liberals and libertarian types and good government conservatives, or whatever they call themselves, like could get together and have kind of an intermediate plus scrutiny for a lot of stuff. And that would be like a better world. And I don't know if that's like the ultimate answer, but there's something out there. Now, how that applies in this case, I don't know. Speech is speech. I think speech has gotten strict scrutiny because usually speech is pretty harmless versus, storing dynamite in your basement. But there's got to be a different system where judges are scared of the scrutiny, and so they get rid of cases on other grounds instead of having maybe a scrutiny that makes a little more sense.
Yeah, I mean, look, porn is everywhere. It's always been everywhere. It's always going to be everywhere. It's just like a different medium in which you can get it than you used to be able to get. Justice Alito did talk about reading Playboy for the articles, so I don't know. So I think that does kind of change the calculus some, and the medium shouldn't change the calculus of what First Amendment scrutiny applies. I'm not suggesting that. But I think it does kind of bring a realistic viewpoint into this, right? Is that, okay, so let's say this age verification law is upheld. Well, all those kids who want to get porn are just going to go get a VPN for not very much money and, pretend that they're in one of the states that doesn't have an age verification law, and so it's, realistically, I don't know how much this law is going to help. Porn, the oldest piece of porn, did you know this, is 40,000 years old. It's a carving on a piece of ivory
that's
from a
not
mammoth
porn, that's
tusk.
art.
Okay, but sexually explicit art. I think it's interesting. It's 40,000 years old. So it's really since the dawn of time. In fact, that may even be one of the earliest pieces of art generally, whether it's sexually explicit or not. So, that's what they're fighting against.
Yeah.
Yeah, it does. I know this isn't really about the constitutionality of it all, but it does seem completely like an empty gesture because, like Diana said, I mean, you go on to most social media, and if you don't like have your settings set up correctly, you're going to get porn pipelined into your suggested for me feeds anyway, whether it's on Twitter or Instagram or Reddit or whatever. And so, like, the thought that kids who are obviously more tech savvy than Ken Paxton aren't going to be able to, whether it's through a VPN or just through accessing sites that have, less than a third of their total content comprising porn, it does seem kind of like this silly gesture that's meant more to signal than anything else. And I think that's probably true too of like, the Pornhub shutting off access in states that have passed these age verification laws. These two are just kind of fighting in public, and this is the mechanism by which they're doing it. And so, like many laws, this is more about the message than actually any sort of practical making the world better, whether you think this would or wouldn't do that.
Yeah.
Well, what's your prediction, everyone? What the court's going to say here?
I don't know. I mean, nobody wants porn in the hands of like little kids, right? Like porn is the porn available today, much of it is like super grotesque.
Right.
And you don't really want that in the hands of kids. And so like that's,
I think I think it also what's driving is the maybe not for the lawmakers, but for judges thinking about it, it's the accidental coming across this stuff by kids, not the savvy kids who can get a VPN. Like they're gonna be able to get it, and that's driving them to like, oh gosh, we gotta fiddle this so the law's upheld.
Yeah, I mean, to me, it still comes down to the question of like whether this law is at all tailored to the goal in mind, because I think everyone agrees the goal is legitimate. The government has the ability and it can absolutely work to prevent kids from getting porn. But the question is whether this law is sufficiently tailored under whatever test you end up applying. And it does sweep in a lot of legitimate constitutionally protected speech. And that's, to me, that should be where the analysis breaks. But with the tiers of scrutiny, that's not where it's going to break at all. It's just going to be, is this protected such that it gets strict scrutiny, or does it get rational basis? The end.
So both of these cases we've just talked about are First Amendment free speech cases. There's no shortage of First Amendment cases at the Supreme Court. Also, if you're talking religion, there's been a lot of religious liberty cases at the Supreme Court last few years. Not so much for the Fourth Amendment, although when we're recording this, the Supreme Court has relisted a Fourth Amendment case that Patrick is a big part of. So we thought we'd talk about this continuing draw. We're not the only ones to ever talk about this, but it really does keep happening. There's this continuing out at the Supreme Court of Fourth Amendment cases, although Patrick's maybe about to bust through. You might even know by the time you listen to this whether it's busted through or not. But Patrick, you're kind of in this limbo mode right now. But whether your case is granted or not, there still aren't that many Fourth Amendment cases. So your thoughts on this?
Yeah. So first, I'm saying we're definitely gonna break the dry spell here today. The good news is coming. Let's go. Going up to the Supreme Court on whether on the important and strangely unsettled issue of whether the police need to check the address on your house before raiding it, which is also curiously an issue in two cases that were relisted from IJ this week, although the other one doesn't actually involve questions presented on the Fourth Amendment. I don't quite understand what the deal is, other than, the court kind of seems to pick like little themes that it's interested in exploring for any term or another. And a couple years ago, I don't know if it was 2 or 3, there were a number of Fourth Amendment cases that came out, like Torres versus Madrid and Lang versus California cases about, what was a seizure if shooting someone while they were fleeing was actually a seizure and those sorts of things. So there have been some, but as far as explaining why they haven't taken more, I mean, I have no idea. So my stab in the dark is, well, we kind of made these seemingly big decisions the last couple of years. So let's sort of let these issues percolate more and see if the lower courts can maybe draw some analogies from some of these cases and see if that helps develop the law in a way that will make it easier for us to address certain Fourth Amendment issues in the future. But yeah, I really don't know.
Well, like if your case is granted, there also is this case that technically is a Fourth Amendment case that was granted earlier in the term. I am failing listeners by not having it off the top of my head, but it's more kind of about liability or cause of action. I think it has something to do with Section 1983. Anyway, what we haven't had, even if your case is granted, what we haven't had in a few terms is like, what is a search, right? Or the really typical core Fourth Amendment case that we had a lot of in like the 2010s, and then they just kind of stopped. And my only explanation is we've got some kind of mix on the court now where it's like there's both sides, if you want to call them that, are not sure of like what's going to happen. So like we're not 4 votes at least are asking for these cases, because there's plenty of cases that are coming up there, and we're continuing to like, what is the latest in the kind of quote property rights revolution about what a search is, what a seizure is, and yet that development just kind of fell off a cliff, and it would be nice to get it going again. I mean, if it's going in the right way, but
yeah, I like I said, I don't have any real thoughts on why that happened, and this could actually be a benefit for the IJ case that we're talking about, which is called Jimerson versus Lewis, because fundamentally it's a qualified immunity case that then is the reason why the Fourth Amendment issue has been thwarted. And so here you had officers raiding the wrong house, and on the qualified immunity appeal, the officer conceded that he acted unreasonably and so violated the Fourth Amendment. It's just that the Fifth Circuit then said that qualified immunity protected him because the Supreme Court's decision in Maryland versus Garrison, which dictates the level of attention that officers have to give to confirming the correct address before executing a warrant, didn't sufficiently give warning to this officer that he had to, among other things, check the address or notice the fact that there was a gigantic wheelchair ramp going to the front door of this house that wasn't supposed to be there. And so it's possible that the decision in this case, if the court takes it up, could focus so much on qualified immunity that this could be a good way for the court to dip its toes back into the waters on these issues and kind of just say, like, yeah, our case in Maryland versus Garrison controls here, and the Fifth Circuit was wrong to effectively say that this officer's decision was reasonably unreasonable, which is effectively what happens because of the qualified immunity overlay. So, but yeah, I don't know why we went from paying so much attention to like aerial searches and stuff to not, given especially the enormous advancements in technology. And of course, IJ just litigated a drone search case in Michigan this past year, Maxon versus Long Lake Township. So these issues are coming up. Why the Supreme Court's not taking them, I don't know.
And Carpenter's another one, right? Carpenter happened. That's the how best to describe Carpenter?
It was the cell site case, right?
Like cell site case, yes.
Yeah.
And like that was a big deal, and then crickets, right?
Maybe it's because the technology is so rapidly advancing, and the court is somewhat concerned about making law in an area that's going to be perhaps outpaced by that technology even 5 years from now.
So we just have to wait till we get to the singularity, and then they can start doing law.
Or they could just take more cases. They take fewer and fewer cases each year, and it's deeply frustrating to advocates. And maybe they should just the perfect ERISA case isn't going to come because ERISA is boring. So just like let us do the good stuff, please.
Yeah, I think I looked yesterday. I think they were at like 55 cases taken for this term. So. And presumably, whatever they decide here in the next few days, either today or Tuesday, will be the remainder of the cases they hear for this entire term. So I can't imagine we're going to break 70.
Unless they pad their stats with like 6 of those. They just grant review to all of the horse cases or whatever.
Well, yeah. And in fairness to them, when they do things like that, they kind of have like an asterisk in that they'll put like the larger number and then in parentheses, like the number that actually resulted in different matters for them.
I see. Okay. Well, then I take it back.
Okay, to close, I'm curious as to what people are consuming in the media environment. But this time we're going to talk about something that you've watched or read recently that you found interesting that is not legal, but also something of the law variety. So our law nerds don't feel left out and can go look it up. Diana, what's tickling you?
So my non-law answer is I'm working my way through John Mackey's autobiography called The Whole Story. And so he's the guy who co-founded Whole Foods. And so it's his story kind of walking through his young hippie days and the young hippie days of the store. He says he was definitely a hippie in Austin, and kind of his way through that into building what is now this huge empire. And one of the things that that's really tickled me is that when he first started building, he didn't know anything about really anything. And so he went in and started renovating this old house to become the grocery store and didn't get any permits. And so the city shows up one day and they're like, "What you doing?" And he's like, just building. And they're like, "Okay, well, you need all these permits." And he was like, "Oh, okay." Didn't realize and then learned that it was going to be just obscenely expensive to do that. And so instead of doing it, he just had all the work done at night when the inspectors wouldn't come. And I love that story because it's just a very quintessential libertarian entrepreneur story.
Didn't they tell him to tear it down during the day though? Then they'd see it?
Yeah, but he didn't. He just kind of got away with it. It's which is just, it's wild, right? You can just, okay, you have all these requirements and it also reminds me of what's going on in California right now, right? Because they're saying, okay, we're going to cut all the red tape for people who want to rebuild. Well, if it's not necessary, get rid of it completely. But anyway, that's a tangent. So that's my non-law book, which always ties back into the law, I suppose. And I've recently been making my way through a lot of writing about Good Samaritan laws. And this relates to a case that I'm doing right now. But there's a really fascinating 2002 law review piece about Good Samaritan food donations and how the laws treat them across the states. And because, people can get sick eating food and, you don't see people suing Panera for donating day-old bread that may have gotten them sick. And so it's the title of this piece is Lost Food and Liability, the Good Samaritan Food Donation Law Story. And it appears in the Food and Drug Law Journal in 2002. So not new, but very interesting.
So do most states have these kind of Good Samaritan laws?
They do. They exempt out this kind of donation, recognizing that you want to encourage the donations and that they're not, people aren't deliberately trying to make others sick. And if you are, you can go after them for in that way. Yeah, interesting stuff. I'm enjoying it.
And Patrick?
So my non-law thing is I went and saw the movie Nosferatu, which is the third version of this movie, which is basically was ripped off from Bram Stoker's Dracula in the 1920s, and has now been remade by filmmaker Robert Eggers in just a great, very this is kind of characteristic of Eggers, who did The Witch and The Lighthouse and The Northman, and now he's done Nosferatu. Very uncomfortable and eerie, set in I think early 19th century Germany mostly, and the travel to effectively what you'd think of as the Dracula character's house and all sorts of bad business that stems from that. And I just thought it was really good, interesting, fun to watch. Well, fun to watch isn't the right way to put it. Enjoyable to watch, though very unpleasant in its themes and its appearance. Movie on this topic that stars a bunch of people, including Willem Dafoe and Bill Skarsgård as the Nosferatu character, which I think is kind of the star of the show. And the way that he talks is very upsetting, and he has a big weird Luigi mustache. And it was great.
Is that the same as the Joker story then, or is that a different Dracula? I'm not up on my Dracula.
So I'm not like a Dracula nerd, but I'm pretty sure that it's more or less a kind of carbon copy of the Bram Stoker's Dracula, where you're going from Northern Europe to Romania, and that's where you encounter this character, and then he ultimately comes back to Northern Europe. And even in this movie, I'm pretty sure he's on a Russian ship, which is probably the Demeter from the Dracula stories. And so I don't think there's much daylight between the Nosferatu tale and Dracula itself.
I got you. I did see the one with Anthony Hopkins in the 90s, Bram Stoker's Dracula. But
was that the Keanu Reeves one?
Yeah.
Yeah. Okay. Well, we won't get into that.
Young Keanu.
But I don't know. I don't have anything nearly as legal nerdy as Diana did, because I don't find myself reading law review articles casually. We're working on one right now that's still in the top secret file, so I don't want to get into.
It's looking good. It's looking good. I saw a sneak peek.
I'm very excited about it.
I haven't, so listeners don't feel left out. I don't know what they're talking about, but it sounds exciting.
Oh yeah. Well, for a fan of law review articles, I think you're going to love this.
It'll be huge. It'll be on all the feeds. You know, when it comes
I'm
out.
20 years behind, as you can see, so it'll take me a bit.
But I will do my best to pivot towards a legally adjacent thing, which is my wife and I just started watching season 2 of Silo on Apple TV, which, if you're not familiar, is based on a series of books which I haven't read, and it's sort of dystopian future set in this enormous silo that's been closed off for hundreds of years due to some unexplained destructive environmental problem on the surface of the earth. And there are 10,000 people that live in this silo that's hundreds of stories tall, and the silo is like stuck in this very kind of early stage of technology. Like the computers that you see have like sort of the DOS prompt look to them, and there's not like advanced technology, and nobody knows why they're in there. And getting out, you can only get out essentially by being banished. And the main reason, the way you get banished, is by saying you want to go out. And so everyone's lives inside of the silo are governed by this thing called the Pact, which is sort of the constitution of what's going on inside of the silo. And
it's like an HOA kind of, it sounds like.
Yeah. Well,
so
yeah,
right
but so yeah, exactly. And so the Pact and the sort of semi-authoritarian state of the way things work, and the caste system, which of course, as you might guess, like the people on the upper floors are the upper class and the people at the bottom are the lower class, and all sorts of stuff. But the reason that this is kind of legal-esque is that you have this pact, and then you have sort of these 3 figures that run the silo, and they're the mayor, the head of IT, and the judge. And so judicial is one of like the bad guys in this show, because they're the ones sort of secretly plotting, and they've got their own police force that's separate from the sheriff, and it's a whole thing. But it's interesting to think about, you know, in this sort of microcosm, the way that law works and can be manipulated and is enforced in, you know, in a way that you can kind of wrap your head around because it's so small, as opposed to like trying to imagine how this works at a national scale with all the practical realities that we face in the law.
Well, great. All right, so I have a couple things. My non-legal thing is, maybe you guys have seen this too. I don't see many movies, but I went and saw A Complete Unknown, the early Bob Dylan story, and I was surprised how much I liked it. Although it may just be because there's a lot of music in there, so if you like Bob Dylan music, then you know you get that, even if you don't like the acting. I thought the acting was well done. Why did
it surprise you? Because presumably, if you liked it for the music, you like Bob Dylan. So I would have thought you'd go into it.
No, I just thought they'd screw it. Partly I thought they'd screw it up because it's easy to screw something like that up. I don't know enough like of the nitty gritty of Bob Dylan's story to like say, oh, that didn't happen. Like say I would with a Roman history movie, but it was really fun, and then. It's subtle, but they kind of poke a little fun at some of the kind of liberal icons in the movie, like Joan Baez, and although she comes off pretty good, but like not amazing, and Pete Seeger. So Pete Seeger's character, which Ed Norton does it. I haven't seen like a lot of interviews of Pete Seeger back in the day, but Ed Norton, I think, does a great job, and you get this amazing earnestness that Pete Seeger had, and he was like way like, I mean, he was accused of being a Stalinist, like way on the left, and you get the sense that he just believed if enough people just got together and sang folk songs, like we would have our socialist revolution, and the world would be a much better place. And you can tell Bob Dylan is like kind of looking at him like, yeah, dude, that's not how the world works. And I'm just going to do my thing.
How could we ever know? How could we ever know?
I think that's kind of previewing later in his life. He kind of like got away from politics and like, this doesn't matter, man, and just do music. But anyway, that's kind of, even though you like his character, you kind of see like you don't really get it, but this young guy kind of does. And anyway, they go up to the like when he goes electric at that festival and famously gets booed and all that, and it's fun. So I recommend that if you haven't seen it. And then this has kind of been the big book the last few months, but I just want to add I have read it too. Against Constitutional Originalism by Jonathan Guinap. I am mispronouncing his name, but I know I've heard it, but I can't remember. And he makes some. So if you're like into the originalist debate, it is a really good book to read. He makes a lot of good points. I don't think like he has a slam dunk against originalism. If you're against originalism in the beginning, you're going to be like rah, rah, rah. If you're not, you probably are going to see some holes. I think he does a good case of showing how it really matters how people thought the law should be read when a law is made. But that can be incorporated into originalism itself, as he kind of lets on where he's like he's kind of intrigued actually by the what do they call it? Our law originalism, or anyway, Steve Sachs and Will Bode have this theory, this originalist kind of theory that is more of reading law the way it was read at the time, which I think is perfectly compatible with originalism. And I think Guinap never really gets to that issue and doesn't really quite understand it, despite all this theory that in history that he does put forward. So it's something you need to read if you're in that whole debate. And I may write something about it, or I may just never have time.
Does he offer an alternative? Does he have a better interpretive theory, or is this just a teardown? Like
most historians who write about originalism, no, he does not have an alternative theory. So if you're like a lawyer and like, okay, so what should the judge do? Just a historian, man. Like,
I'm just asking questions.
A little bit. It's a little bit like that. Like, it would be a lot more helpful because there's a lot of historians who have done stuff like this, if they offered their own, well, this is what you should do.
Or at least offered because they're historians, at least offered like historical principles actually support this instead, or right. something so that you can draw an affirmative conclusion and not just a negative one.
Yeah. I mean, like there is this alternative view that a couple scholars recently have put forward of you should be a textualist, but you should read written text as it is today, even if the words have changed, because it's consistent. Like, there's all these pragmatist reasons for that. Like, he doesn't even do that. He just like, oh, history's weird, man.
So like how the word literally used to mean actually literally, and now it means anything goes.
Yeah, I'm not a fan of that. Did I use literally in a bad way?
No, you didn't. You were talking about how use the words as they are today, even if they've changed.
Oh, I see.
Literally has made a 180 degree change from its original, or not original, from its previous use. I don't actually know.
Well, some of us are still
etymology of it.
Fighting for the old ways.
I mean, I don't use it outside of like actual literal, the old literal, but I know a lot of people do. So
I hope that's literally true, Diana.
Literally.
Well, thank you, everyone. This has been an interesting conversation. I hope you, everyone, enjoyed the live TikTok, which, probably events have overtaken us, and either it's meaningless court opinion, or it's been rescinded, or God knows what's happened. But things come at you fast, as they say. So thanks for listening. We'll be back. I think our buddy John Wrench is probably going to host the next show. So maybe I'll see you guys in a couple months on this feed. But until that time, that's just like your unpublished opinion, man.
I'm gonna do like a gentleman. Go and get some hops. Get myself a gun and shoot myself a cop. I ain't had